My name's Nochumson. I've been practicing law for almost 20 years, and I've had my own law firm for well over a decade, and I've been writing a real estate column for the Legal Intelligencer, a monthly real estate column for almost 15 years. So if you go on my website, you'll see I think over 125 articles. So at some points I was a monthly real estate column, sometimes I was every other month. But anyway, there's a ton of real estate columns on my website about real estate law. And there are basically two areas that I really write about a lot. One is landlord-tenant law, and I teach a landlord-tenant class here as well. I find it's common sense, and it's just like this topic, agreements of sale, which I have a ton of articles about. Actually, there was a recent case, I think it was a Superior Court case, which interpreted the Seller's Property Disclosure Act for the first time as to what effect would as-is, whereas condition have on the obligations of a seller to a buyer under the Seller's Property Disclosure Act. And we'll talk about that as well. But it's just interesting. I always try to focus and follow whatever type of cases the Superior Court or the Supreme Court are writing about real estate law, and it's not a ton. So I get to see almost every case out there or an opinion that makes sense. Again, look at my website. You'll see a lot of those cases out there. But we're going to talk about agreements of sale. And just like the landlord-tenant law, I tell people, has anyone been a landlord before? Has anyone been, a tenant before? Obviously, most people have in their lifetime. Same thing with agreements of sale. How many people have ever purchased real estate in the past? I would say that probably most of the people in this room, and probably of those people, most of them also have sold real estate in the past. So, we're going to talk about residential agreements of sale, but they kind of go hand in hand with commercial, agreements of sale. When you're purchasing or you're selling real estate, you have two different perspectives. And as an attorney, you have two different perspectives, right? So I handle a lot of agreements of sale where people are, I either handle it when they have realtors or when they don't have realtors. Now, Pennsylvania is not an attorney review state like New Jersey. I'm licensed in Jersey, I'm sure a number of you are as well. And if you ever hear handle real estate transaction as an attorney, you know that there's an attorney review period in New Jersey. Pennsylvania, that's not the case. So in Pennsylvania, a lot of times attorneys never, or people, a buyer or a seller not represented by counsel. Sometimes, though, even if they have a realtor, they want an attorney. And a lot of times these for sale by owner situations, which I handle a lot of, they need an attorney to help draw up the documents. So the perspective is different. If you're representing a seller, you're thinking one thing. If you're representing a buyer, you're obviously thinking another thing. So the first thing, obviously, people always think about is the sales price, right? How much is the property going to be sold for, right? So when I'm representing someone, I act as a quasi-business advisor as well, because I ask them these questions. I always say, hopefully you didn't enter into an agreement in principle before you got involved with me, because sometimes, whether you're the buyer or the seller, the other side's going to be upset because I'm going to talk to you about terms that are maybe different or additional than the terms that are, what the parties thought about. And even the sales price, right? So when you're drawing up an agreement of sale, whether for a buyer or a seller, if you're representing a buyer, you're like, okay, how did you come up with this purchase price, right? A lot of times the buyer will say, well, that's how much the person asked for, so I figured I'd pay that. And I would always say, well, just because someone asked you to pay that price, well, we're not going to a department store, we're not going to a convenience shop. There's negotiating, right? You can negotiate, right? A candy bar is a candy bar, right? You're not going to negotiate that. But big piece of real estate, it's just like a car, right? You go into a dealership, you're going to negotiate a little bit. And, just like a car, right, you have a lot of information on the internet nowadays, right? So with real estate, you may go onto the Office of Property Assessment website. When we're talking about Philadelphia deals, right? So we're in Philadelphia, let's focus on that. Office of Property Assessment website will show you how much the city has assessed the property as, right? So you may want to know that, right, from the get-go, because the city right now assesses property on a fair market evaluation. So whatever they consider the fair market. Now, the city screws that up all the time. That's why I have a job, dealing with tax assessment appeals. But, maybe there's some rhyme or reason as to why they're assessing the property. So you may want to look at that. You may want to look at how they're assessing other similarly situated properties in the vicinity. you also have like the public record, right? You can see like you go into Trillia, Zillow, whatever, Realtor.com. Not only do they show the properties that are listed for sale, they also, you have components where you can see how much properties were sold for within certain time periods. Again, you want to look, and talk to your client on it and make sure that they're informed whether they're buying or selling. So if I'm the buyer, I'm like, okay, let's look at the comparables, right? And the other thing we're going to look at when I'm representing the buyer is how long the property's been on the market. Again, this is just, a lot of it's just human nature. We're just trying to memorialize a contract, but we're trying to give that extra added value that I hope to give. Because again, I do this over and over and over again. People who buy real estate, if you're just buying a house and you're not as an investor, you're probably buying a property, three or five properties over the course of your lifetime. So you're not doing this a lot. When you do it a lot, you want to give that experience and add value to your client as much as possible. So when you look at like how long the property's been on the market, right? So again, it's human nature. When a property's on the market, not that long, right? You're then thinking, hey, as the seller, I can keep this property on the market for a while. Like I feel strong, right? If the property's been on the market a while for that particular price, then you're thinking as the buyer, well, that person may decide to go down in price, right? So that's something to consider. Also, if this is on the multi-listing service, you can see what the starting list price was, and then you can also see if there has been any price drops. The longer it's been on the market, the more price drops there have been, the more helpful that is for a buyer to know that, because maybe the seller's a little bit what's considered soft. On the flip side, the shorter the property's been on the market, the less price drops, the maybe more reasonable maybe the list price is, the less likely the seller is going to drop. The other thing to look at is if you go onto the public records, you go on the recorder deed site and see maybe there's a mortgage against the property. How much is the mortgage, right? This market is, you're going to see people have a lot of equity in their properties, right? So you can know how much equity, how much fact is really on the deal, how much profit is the seller potentially going to make, right? But there's also like when it's tight, sellers may not be able to accept a price under a certain amount, otherwise they would do what's considered a short sale where they have to ask the mortgage lender how much is potentially, that they're going to have to come up themselves with to make the deal happen. So those are things to think about. So let's talk, so the first thing is how much is the purchase price or how much is the sales price? Well, another thing to think about is like how much money is going to be placed in earnest, like in escrow prior to closing, right? So this is another thing to focus on. If you're a buyer, you want to put as little money down as possible because it's being held in escrow. So what does escrow mean? And I'm sure many of you know, the seller has an interest in that monies, and the buyer does as well. So unless both sides turn the proverbial key, that money cannot be released by the escrow agent. Usually the escrow agent is the title agent, or they're the attorney in some cases working for sale by owner situations. I prefer not to hold the funds because it's a conflict, because if I represent the buyer or the seller, and like that money's held in my IOLTA account, for instance, and then there's a disagreement, if I represent the buyer, I can't release the funds. If I represent the seller, I can't release the funds unless both sides say yes, because otherwise I'm putting myself at risk that someone's going to like potentially sue me for an improper release of the funds. And by the way, like I talk fast, so slow me down if you want. I also willing to take questions too. Yes, because you could just read my material. So yes.
In the old days, we used to open up a separate account,
yeah,
money in escrow.
Okay.
Still happening?
Yeah, I put it, well, so my bank, they don't like have sub-accounts. When I was with Bank of America, we would have sub-accounts that were specifically created. Like now, I just throw my...
I'm just talking like going in and opening up a bank account.
I don't do that. I don't personally do that. I also had a title insurance company at one point where the funds would be held in my title insurance company account. I don't do title insurance anymore, so I just keep it in my IOLTA account. But regardless, like, I try not to hold those funds because, first of all, it's an administrative pain in the ass. I'm not getting paid for it. And, like, it's too much of a risk of conflict that I prefer to know who I try to get the title company like on board as soon as possible. When it's a for sale by owner situation, I'm representing a buyer, I'm like, who's your title company? Let's put that in the agreement of sale. If they don't have a title company, I'm like, here's recommendations for how many you want, and let's get it into the title company's funds account anyway. And because the title company is the quarterback of the deal anyway, they're distributing the paperwork and the funds anyway. I don't want to have to then write a check or wire the funds, cost me money or cost me client money. So security deposits, like when is it due and how much is due. So how much is due? Buyer wants to be invested as little as possible because those funds are being tied up, right? Seller obviously wants as much money invested as possible because if the deal goes sideways for whatever reason, technically, those funds could be held if there is some type of breach on the other side. When those funds are due, right? So a lot of times I recommend to my buyers to put as little money down when they sign the agreement of sale because they have no idea what the property is really like worth because you have to get an appraisal probably if they're going to get financing. They also have to do due diligence, like inspections and other things. So I'm like, listen, like typically I ask them to put like $1,000 down, right? Put $1,000 down, and then maybe we'll have a secondary deposit of a certain amount. Now, if I'm representing the seller, I'm like, listen, I'm not taking this property off the market unless you put some real funds down because I got to make sure that you're committed and invested in this deal. So, typically, again, I have a secondary deposit after the due diligence period ends. And for residential deals, due diligence means your inspections are done, right? So you're going to have typically a general property inspection, you're going to have a termite inspection and a radon inspection. And then I would have real funds committed to the deal if needed, if I'm representing the seller or if a buyer wants to put a strong offer together, right? So, settlement date, that's another item that's like, again, if you want to put a strong offer together, if they're competing offers, if you're a buyer, you're going to try to get a settlement date as quickly as possible, right? Because the seller may be anxious. You don't know what, and it could be a situation where the seller may say no, but the seller's putting his property on the market. It's a very stressful situation. We've all been there where we have a property on the market, we're looking out for a property ourselves. Maybe our kids have to go to a certain school district or make sure they're within a certain school district. We all have time frames. Maybe we're leaving in the area. So time sensitivity is usually a big thing for sellers, right? The quicker you have a settlement date, the better of an offer it is. But then there are sometimes the seller's like, you know what, I'm taking my time. Like, you got to know what they're all about, right? They may want to take their time to look for something in that sells. They may say, hey, listen, I appreciate the quick turnaround, but I haven't found something myself, so I need to figure out what I'm going to do. So that may be a conversation. Again, well, these are certain things that you have conversations before you put an agreement to sell together. Now, a buyer may have other thoughts as well. Like they may not move to the neighborhood or the area like right away, so they're going to be carrying a mortgage potentially. They may be like marketing a property they're selling, and that may be a contingency where they have to sell their unit or sell or settle or get under agreement where they can carry two mortgages. So it just may be impossible for a buyer to actually potentially cover two mortgages, even if they want the house so much. So you got to have those conversations. I mean, like again, we're just one portion of their deal. Like they should have a team of advisors. They should have a banker who's going to fund whatever loan they have if we're representing a buyer. They need a title insurance agent. They need us. They need to have an insurance broker because they're going to have to get property insurance. And they're going to have to get an inspector, like a good inspector who's going to be able to do the property inspection, termite inspection, and radon inspection. So those are their team of advisors. We're just one part of it. So that goes to another thing besides the settlement date is one of the things that people get concerned about is people trying to do get a second bite of the apple. And I don't know if I'm going in order of my materials. It's the inspection period, right? So say we get under agreement, say we agree to a purchase price, say we agree to a settlement date, say we agree to how much money will be down prior to closing. Sellers get very concerned when there's an inspection, right? So sometimes you can just say, hey, the property is just going to be taken as is. Very rare that happens even in this top market. But if there's an inspection done, usually there's a contingency period of X amount of days, right? And then under the PAR form, the Pennsylvania Association of Realtor form, what typically happens is that during the inspection period, the inspections are done by, it has to be a duly licensed professional, like an inspector, and a report has to be given to the seller. Then within that period, the buyer has three options under the card form release. They can accept the property in as-is condition, and then they waive that part of the inspection, subject to any type of disclosures that were required under the Seller's Property Disclosure Act, which we'll talk about. They can terminate the agreement, and whatever deposit funds are with the escrow agent, whether it's you as the attorney or a title agent or some third party, would have to be released to the buyer, again with the approval of the seller, or the buyer can propose or give the seller what's called a written corrective proposal, right? Where you say, listen, I did the inspections, right? I want either this work done, right, prior to closing in a good and workmanlike manner, or I want a credit, like what's called the seller's assist, and the seller's assist is this, is whatever the net sale proceeds are, the seller then will give a certain portion of it, whether a percentage of the purchase price, or in their mind, sales price, or a certain amount, right, to the actual buyer at the time of closing. And that helps them because if there's work to be done, the seller's assist will help them fix that work themselves. Or we can have a reduction of the sales price, right? So, if there's a lot of work to be done, that may be an issue for the buyer's mortgage lender, so you have to be careful. And even with the seller's assist, not all mortgage lenders will accept seller's assist because they want to make sure that, why are you getting seller's assist? Well, there's a lot of work to be done. Well, that's my collateral, that's my asset, right? In case you default, yes.
Yeah, are there any fundamental differences in the attorney's perspective or approach based on whether or not you represent a client that doesn't intend to hold the property, intends to flip it?
Well, yeah, so I represent a lot of investors. So you mean from like, when someone's purchasing a property as a shell, or as a vacant lot, and then just buying it to then renovate it or do new development? Yeah, so and we're going to talk about that, and that's some of the other contingencies. So I represent a lot of investors. That's why I'm doing zoning matter. I'm going to run back there, and I had 3 of them today. So if you're representing an investor, some of the things to focus on. Let me just finish that last part, and then we can go. So some mortgage lenders don't allow for a seller's assist or of a certain amount. So that's something to keep mind of. And then if you choose the written corrective proposal portion of this equation, and it doesn't have, this is what the par form does. Like, you don't have to do it, but like it's easy to like focus on the par form because it does create a regime that it's kind of like makes sense. Then if it's a written corrective proposal, obviously the work needs to be done within prior to closing. I try to have a second inspection done. If I'm representing a buyer, I want to make sure that work is done in a good and workmanlike manner. I don't want to go back on the day of closing and then my client's like, oh, the work wasn't done, and or it's crap, or they don't know better, and then after closing they realize that it's crap, right? And then you got to go chase down the seller. So I try to again make sure that there's a second inspection prior to that point in time. Going to your point, yes.
You put that into the agreement of sale up front, or is that a point of negotiation during the contingency period after the inspection?
You could do it one of 2 ways. I mean, like again, it's not typical in the par form. So if you're representing a buyer, I would wait until you actually have to do the written corrective proposal, because it's going to be an amendment to the agreement of sale. Once the seller signs the agreement of sale, you kind of got them a little bit, because now they took the property off the market, whether it's in a multi-listing service or this generally. They have a mindset that they already sold this property, but there's a lot going on between the signing of the agreement of sale and closing. So if I'm representing a buyer, I wouldn't put it in the main agreement of sale. I would wait and do a written corrective proposal, and I would say I would like to inspect that work. What is the seller going to say? I don't want you to inspect the work? Well, then if I can't inspect the work, well, how am I going to trust that you're going to get the work done? Now, from a buyer's perspective, when I represent buyers, I try to take the money. I mean, there's a risk involved, right? Like if you're going to reduce the sales price, or the purchase price from the buyer's perspective, or you're going to take your seller's assist, you're taking the risk that you don't know what's behind the walls, right? So, you say, like the inspector, again, the inspector only looks what's, what's here, right? So we don't know what's behind this wall, right? And, there is a Property Disclosure Act where the seller is supposed to disclose any material defects that they know of, but we know people who are not truthful, right? Or maybe ignorant, so, just do not know, right? And so, you take that risk. So if an inspector sees order stains, well, now they know that there may be something wrong here, but until they kind of unpeel the onion, so to speak, they don't know. So if you're taking the money, you're taking the risk as the buyer. But if you then tell the seller to do the work, the seller has no incentive to do a great job, right? So they're going to hire human nature. They'll hire crappy contractors. And by the way, if you have the seller do the work as a buyer, you got to make sure that they're fully licensed, that there's proper governmental applications and permits, and they're fully insured, and what type of warranty there is. So, but there's a lot more babysitting with the buyer babysitting the seller and their contractors. So there's no rhyme or I would prefer the money, but because as long as my client has financial wherewithal, and depending on what they're going to do, right? So that is a good lead into investment properties. So let's just yes.
When you have a client that's a difficult client who doesn't take your advice, do you ever have them sign something where they say that over your recommendation they're going to go do this?
Is there? I thought they're all difficult. I just thought they were clients.
You know what I mean?
So I do a lot of CYAs. Yeah, I do. Because my practice is whether it's text or email. There's especially with something like that. Yes, you put in something in writing. You just got to. The problem is look how much I talked about in 5 minutes, right? It's really hard when people have busy practices to be able to put those emails together. So I have some form emails where even putting the agreement of sale together, I have certain canned passages of emails to kind of go through some of those scenarios. So yeah, that's clearly one that you need to focus on to deal with.
When you know there's going to be a problem.
Well, yeah. If you have a difficult client, you got to, as much as possible, paper your file. I think you should paper your file anyway. I have clients all the time who are I don't know. I have one client who's a year later on a loan transaction. He's like, well, why did we agree to this? And I said, because you told me to stop negotiating with them. You just want to know the general particulars of the deal. And I said, this is a potential. So there's always clients who have an uneven memory, so to speak. So yeah, you have to paper the file as much as possible. So yeah, it doesn't matter if the deal is $10,000 or $10 million. It's really the same structure and components of the deal, right? It gets a little bit more sophisticated with commercial. It's just a couple extra zeros. In my mind, seriously, it's a couple extra zeros. And it's nothing else. And dealing with the individuals, I'm doing a deal right now, where it's $3.5 million. I don't think that the client is as sophisticated as some of my more residential clients. So you got to really figure out who your client is. So going into in terms of an investment, let's just talk about a rehab, right? So you have a property which the person's going to say, oh, it's an estate. This is my former parents' home or deceased uncle and aunt. It's dilapidated. There's a ton of tax liens on it. Yada yada yada. You're going to clean up the tax liens, obviously get title insurance, stuff like that, right? And by the way, the other thing to make sure is when you're dealing with an estate, make sure you have the letters of administration. See who you're dealing with, right? Even when there's a power of attorney, right? Make sure the person who's signing the agreement actually has the authority to sign the agreement, right? Make sure you have all your I's dotted and T's crossed, right? So, even when I am representing, and I know I bounce around a lot, but when I am representing a husband, I'm like, oh, all right, someone calls, I want to buy property. I'm like, are you buying with someone? That's important to know, right? Or if you're selling it, are you selling it with someone? Oh, I see 2 names on here. One of them is yours. Who's this other person? We just got to make sure we account for those people, because down the line there'll be title insurance issues, right? So we waste all this time on due diligence, inspectors, me, whatever, and then you're focusing on, at the end of the deal, well, there's all these conditions to get good title. I need to see letters of administration, I need to see this, I need to see that, and it doesn't happen. So let's just say we have a shell of property, right? First thing we're going to do when we're representing someone, and by the way, this is anything. Philadelphia, you get what's called from L&I a certification statement, right? you see what the zoning of the property is, you see what the current use of the property is as of record. So all they do is spit out of record. They don't do their own independent investigation. You can order it online, it's like $110 nowadays or something. And it's required, it's a resale certificate, right? And then you see if there's any violations of record. That's important, right? Because when you have these like compromised, distressed properties, you gotta see what the violations are and, if, they can be dealt with prior to closing, or what happens if they're not, there's technically, potentially fines on that, right? But you wanna make sure the zoning's correct, right? So, I don't know how many people do zoning, but, there's all these designations, RSA 5, RM1, CMX1, yada, 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 yes.
If you buy an RA5,
A what?
I think an RA5 is for a single home,
RSA 5, yeah.
right, RSA5. And if you want to turn it into duplex, how difficult is the process?
It depends on the neighborhood. I do a ton of zoning work in Philadelphia. So some neighborhoods are more difficult than others, right? So it really depends on the circumstances. So if you want to do that, you could potentially put a zoning contingency like in there, right? I have a certain period of time to get this certain type of zoning, and that's common. But that makes the offer weaker, right? Because the seller's like, I'm going to waste time, like 90, 120 days, 150 days, depending on how complex the situation is. No, I'm not going to take it off the market. I'd rather get $5,000 less, right? Or maybe you give me money, hard money, right? You give me a certain amount of money, and regardless of when you get the zoning contingency, right? So it really depends on the neighborhood, right? So this is why I tell people all the time when I do zoning. If I walk down that block and I walk by the property that you're developing and it's built and it doesn't stick out like a sore thumb, and I just walk by it and it looks like it fits within the fabric of the neighborhood, it's very likely you're going to get zoning approval, right? But you also have to take the temperature of the neighborhood. There's always a breaking point. Oh, there's too many duplexes, parking's an issue, yada, 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 gentrification, like, tax assessments are going through the roof, like, so you have to get a flavor of the neighborhood. So, like, in my practice, I actually do all these things, right? So, but you may have to, like, consult with a zoning attorney beforehand. So you gotta say, is this something besides drafting the agreement of sale, do I feel comfortable giving zoning advice? Otherwise, you may have to say, that's something you have to talk to with a zoning attorney. And it's not just use that you have to worry about, it's dimensional as well, because the zoning code only allows certain dimensions, right? So a certain height, like RSA 5 is 38 feet high, right? I have to have an open area of percentage-wise of 20, depending on the situation, 20% of the lot or 25% of the lot. My rear yard has to be set back a certain amount depending on the square footage of the lot or the depth of the lot. So like there's all these issues to focus on when you're doing a development project. So when you're doing a rehab, you may not have to deal with those issues. But you may have to do a little bit more due diligence now because you may have to get a structural engineer. It gets a little bit more sophisticated, right? The other thing is, again, this goes after closing. If you're representing an investor, make sure they get their tax abatements in. There's a lot of stuff going on there. But zoning is a big thing, right? So if, we're buying an investment property, hypothetically, where it's a 2-unit or a 3-unit, has 3 meters, doesn't mean that it's legally used. I have a job, I do a lot of work to legalize triplexes and duplexes in the city. You gotta make sure that the use is actually legal, right? So that's something to focus on. Did I answer your question a little bit? Okay. The other thing to focus on is, again, some of the closing costs, right? Because, if you're a buyer, maybe, and even the seller may, they may have a lot of money in the property, like equity in the property, but they may be thinking they're gonna get a certain amount. Do they factor in some of the closing costs, right? So for whether it's a buyer or a seller, do they factor in the realty transfer taxes? So in Philadelphia, well, in the state, it's 1% of the purchase price or the sales price. And for Philadelphia, it's now 3.278. I looked it up. They keep changing it. It was originally 3.1%. They recently raised it up. So typically, those costs are split evenly between the parties, right? So the 4.278, so just say 2%, right? Let's just make it easy, right? $100,000, 2% is going, of the 4% is split evenly, 2% each, 2% for the buyer, 2% for the seller. But these are things to focus on if you're thinking about a purchase price or a sales price, right? But the parties can agree. Like I said, this $3.5 million deal I'm doing this week, the buyer is willing. It's an investment property. It's an apartment building. He purchased it. They're purchasing for someone who wants to really sell it, but they're like, listen, you pay the purchase price. You pay the transfer taxes. So, yes,
Are the realty transfer taxes applicable in co-ops?
in co-ops, what do you mean?
Well, when you sell a co-op, if you're really not selling real estate, it's the stock.
I would have to say that unfortunately, I don't, like Philadelphia doesn't really deal with a lot of co-ops, so I haven't dealt with co-ops. I've done with planned communities, condo associations, condo buildings. So, but there's a purchase price, right? So I would think it would be based on the purchase price. So that's how it works. Yes, yes.
There are people doing private trusts. So they set up a trust for the property, then they transfer it, then they acquire the property, get it under contract, they're the beneficiary, then they're also beneficiary or an assignee of the trust, then they sell the trust and change the beneficiary.
You know, I think there may be transfer tax. I'm not a transfer tax expert by any means. There's certain lanes I stay in. So when you're dealing with trust and estate work or some corporate work, I kind of stay away from it. But as you saw in the news, like even yesterday with the New York Times article, like, you know, people try to, manipulate like the situation so they don't have to pay trust to pay estate taxes or pay potentially even real transfer taxes.
If you take you get a property under contract and payable to, you're the purchaser or your designee, and then you sell the contract, so you're basically wholesaling it.
That's right. So then
In that case, you're transferring personally, you're not transferring real property, so
I don't know if that's correct. Again, I don't do, like, I'm not a transfer tax expert by any means. I think there is a tax on the actual assignment because you're getting, if I'm under the contract and I assign it to you and you give me $50,000 for my rights, well, there's value in there. So I think there is realty transfer taxes that you do. One of the things I do for that situation is a lot of times, I just had a client who's trying to enter into an agreement for a nice piece of land in Port Richmond. He's going to be personally on there, and he'll have the right to assign the contract to any entity he controls. So what we said this is that if he does that, we will be able to terminate the contract, and the parties are obligated to enter into a new contract with this entity. So there's no assignment, right? It may be form over substance, but like because if you look at the realty transfer tax form for Philadelphia, there's actually a question: was this transaction part of an assignment? So you have to answer truthfully, right, under penalties of perjury. So here it's not, because like here we terminated the contract, and we then entered into a new contract with all the same terms. Like if there's a due diligence period that expired, well, then it expired on the new contract as well. But like, I think that's a cleaner way of doing it. And like a lot of times I'll see, and I'm not a realty transfer tax person by any means, but like they used to have it where you used to buy the company that owned the real estate versus the actual real estate. They closed up that loophole recently. But there are a lot of times where people still do it, right? You don't have to tell the city of Philadelphia, I don't condone this, right? But like you'll see people sell a company, and then how is the city of Philadelphia or the government supposed to know that, this was a sole purpose entity that was sold, the stock was sold, right? It's very hard to find that out, at least from the city of Philadelphia rules. So, people get around that all the time, whether legally or illegally. So, but realty transfer taxes is one of the bigger closing costs. Obviously, title insurance is another one. So, if you represent a buyer, they should reach out to a mortgage lender to kind of get good faith. It's not called a good faith estimate anymore, but an estimate of what the closing costs are, just to make sure they can afford it. And from the seller perspective, making sure that they can afford to sell the property. They may want to potentially get a payoff from their bank. They get the mortgage statements all the time, but like just to see what potentially what their closing costs are going to be too. And then I'm sure most people know what title insurance is. Title insurance is unlike any other type of insurance. Title insurance, like most insurance, like health or auto insurance, right? I'm paying premiums over time to protect me against future events, right? Like I'm being insured. Title insurance is a one-time payment regulated by the state, depends on the purchase price. I'm going to pay it at the time of closing, right? You can go do Pennsylvania title insurance calculator, right? And it'll tell you how much you're going to pay for title insurance. It insures you from the day of closing backwards. Does the person who's selling you the property, can they actually sell you the property? Convey an interest in the property, so you own it, right? Are there any liens and encumbrances against the property, like monetary? At the time of closing, there can't be any liens and encumbrances if you're getting a loan from a bank, monetary, right? There are liens, there are encumbrances like easements and things like that at the time of closing, which are typical. Or there may be like, if we're dealing with condos, like or co-op, there's going to be some type of document of record that created the condo or co-op. There may be a right-of-way agreement. You just got to look at those things. And that's another thing. When you're an attorney representing a buyer, you got to make sure you read the title commitment. There are exceptions to the title commitment. You got to see what those are. You also have to see, making sure they're not going to close, but like whatever you see on the title commitment in terms of conditions, like judgments or whatever, you got to make sure that you keep your focus in making sure the seller, especially if they're unrepresented, deals with those prior to closing. And then this is where, if you haven't done your homework, and there is an estate, like you ask those questions. Do you have the death certificate? Do you have the letters of administration? If it's a POA, a power of attorney, do you have the power of attorney? Has it been recorded or is it unrecorded? Even at closing, there may be a power of attorney. So like these are things that you're going to focus on at the time of closing, but it's helpful to have it at the beginning of the transaction. The more you do up front, the less you have to do in the back. Also like personal property. What personal properties included? Some of the investment properties. We have appliances, right? Make sure those included. There has to be a bill of sale at the time of closing, right? Or if there's leases, we got to make sure there may be a due diligence period. I need to see like how much those leases, like how much money those leases are generating in terms of income. Also, like I got to make sure that there's a housing inspection license of record, that the tenants also got what's called a certificate of rental suitability and the Partners for Good Housing handbook. Like that's more going towards my landlord-tenant thing. But these are things that are very important, and making sure that you have all the contact information for the tenants at the time of closing, whether it's email addresses, telephone numbers, things like that. A letter goes out, and this should be in the agreement. A letter goes out at the time of closing, whether it's from you as a buyer, your management company, or the one that you hire, or the seller saying future rents should go a certain place. How the rents are going to be applied, right? The security deposits, first month, last month. These are things that you have to pay attention to. Maybe it has to at least be generally in the agreement, but then you focus it on the settlement statement as well. And I would make sure you get the applications for the tenants if they exist, because what happens? You have to evict these people. So the biggest thing is look up the word certificate. Look up the term certificate of rental suitability. If you don't have one in Philadelphia, it's bad news, and you have to get it technically within 60 days from the lease inception, and any type of renewal of the lease as well. Residential only. So a certificate of rental suitability. Yes.
Is it typical when you're purchasing a rental property to get an estoppel certificate from?
Yeah, we could. I mean, okay. So an estoppel certificate, I'm just going to explain, is like basically I'm going to get it from both the landlord and potentially the tenants. Where this lease. This is whether there's amendments or not. This is how much rent's being held in security deposit. This is what first month is. This is what last month is. Whether there's any defaults against the lease. Whether there's you're just basically covering all your bases. With residential, it's harder, right, to get a residential tenant to sign that. You may want to just get the landlord to sign it, and make sure that you have a clause where it says this provision will survive settlement. Otherwise, any provisions of the agreement of sale merge with the deed, right? So you got to make sure that if you want any provisions that go beyond the settlement date and the deed execution, you put that in there. But yeah, for commercial, yes, you can definitely get some stop letters. And by the way, your bank's, if you're getting financing, your bank's going to require it too. You also want to get, we're working on this deal on Walnut Street this week. You're going to want to get rent bills too, right? You're going to want to get that certified by the actual seller, right? There's going to, and when you're dealing with a more commercial transaction, there are going to be reps and warranties about a ton of things, right? And you're going to want at the time for them to sign a closing certification saying that all the reps and warranties are also true and correct as a date of closing, and they will survive closing for a certain period of time. Again, survive closing, otherwise they merge with it. So, mortgage financing, right? It's really important, like, to know if you're the seller, if it's cash deal, it's great, right? You know, then that's a more attractive offer than financing, right? Because you don't know if this buyer can get the financing, right? So the par form has a personal information statement where you can ask them for how much they have in the bank and how much income they make and how long they've been employed and by whom and, you know, what other assets they have and then what other debts they have, right? So that's something that you may want to consider. Again, we're not trying to go too much in there. You just ask the question. Do you know who this person is? They say they can afford it, but do you really know? You won't know until potentially if they're getting financing, until they apply for the mortgage and they get it denied potentially. So, but the other thing with financing is you got to make it as tight as possible if you're the seller. Who are they applying for? Like, who are they applying with? Are they applying with Bank of America, or is it going to be some independent, like some Loan Depot, or some BS type of like mortgage lender where they're going to try to get as low as possible? Sometimes they put to be determined. If I'm representing a buyer, I put to be determined. Let me figure it out, right? You know, how much are they borrowing? Are they borrowing 100%, 90%, 95%? Like, how much money are they actually putting down at the time of closing, right? The more money they put down, that's better, because that means they have better financial wherewithal. What's the interest rate, right? There's a maximum interest rate that they should be able to do the deal, right? So what's the going rate, right? I don't even know what the going rate is. Let's say it's like 4.5%, right? If I'm representing a seller, I'm like, listen, you as the buyer should have to do the deal if the rate goes up to like 5.5%. If I'm the buyer, I'm like, listen, I'm running the numbers at 5.5%, I don't want to do the deal. So that's always a fight. Are there any points on the deal? And then when do they have to apply for the mortgage, right? So like the quicker they apply for the mortgage, hopefully the quicker they get the mortgage commitment. When's the mortgage commitment date? That should be written in the agreement. Is the deal conditioned on an appraisal? So it's implicit that if you can't get mortgage financing because the property doesn't appraise, well, I don't believe in that. I believe to have an appraisal contingency if I'm representing the buyer. So I create my own buyer appraisal contingency. But the par form has an appraisal contingency where the appraisal contingency is only for X amount of days from the time the contract is fully executed. I have something more open-ended because I'm representing a buyer. I can't control when the mortgage lender is going to get their appraiser out there and to know when that's going to happen. So those are other things to focus on. We talked about the seller's assist, parking inspection, title insurance. If it's a condominium or a planned community, you're going to have to review those documents. If you're, you know, just generally. So like if you look at the par form, it's usually a 5-day review period. The deal is voidable until I have a review of the condominium documents or the planned community documents if I'm buying from someone who already owns that property, like not the developer, which is called the declarant, right? So if you own a condominium unit and I want to buy it from you, I want those documents. I want what's called for a condominium a 3407 certificate. It'll tell me what the assessments, the monthly assessments are there any special assessments, are there any capital improvements that are on the horizon, what the budget of the condominium association is, how much of the reserves they have, is there any litigation potentially pending there, or, you know, just things like that. I don't want to buy into a building that doesn't have a lot of reserves, that has a lot of capital contribution on the horizon, and special assessments that maybe do. So like you got to look at the financial health of the condominium association and or the homeowners association if you're a planned community. Then you also look at the rules and regulations. I tell you, I deal with ad nauseum people who are upset with their homeowners association. What, you know, are there restrictions with pets? Like if I have a lot of pets, I need to know, is there a dog policy, a cat policy, like what it is. If it's an investment property, there's limitations sometimes of how what I can rent it, how long, like it could be an Airbnb situation. They may say, no, you have to rent it at least 6 months, which is typical, right? Or there may be a limitation of how many units can be rented because, and this goes to the buyer as well, you don't want so many units to be able to be rented because that may make it so that you can't get certain type of financing. The more rental units, the harder to get financing. Generally, if you want to own a property and you live in it. But on the flip side, if you want to rent it and there's limitations, you got to be wary of that as well. And if you're buying the property from a declarant, right, someone who has developed the property, you get what's called a public offering statement, where you get a ton of documents, which I typically prepare as well for clients, and you have 15 days. I think for planned communities it may be 7, but for condos it's 15 days to review those documents. And again, it talks about the financial world, it talks about just the rules and regulations, the declaration, the bylaws, the budget, what the components of the of the building are. And if you're dealing with new construction rather than like, a pre-existing one, are you getting a builder's warranty? If it's new construction, you are going to get a builder's warranty, right? So what's the scope of the builder's warranty? I'm dealing with a guy right now, he said he was going to get a builder's warranty, and the developer gave him something that was 1 page, and I was like, this is laughable. I'm like, really? No. And I think he actually even spelled the word builder wrong. So I'm like, okay. So those are things to focus on. And then, like, if you're dealing with new construction, the property may not even be built at the time that you buy it, right? I mean, that you're under contract. So if you're getting a property that's new construction, well, you got to make sure the specifications are there, right? Because you're like, oh, I'm going to get a fridge. Well, what type of fridge, right? I'm going to get flooring. What type of flooring? May not even be what type of flooring. Like, what's my allowance for the floors? What's my allowance for the fixtures? What's my allowance for the kitchen cabinetry? My allowance for the countertops? And then, you have to have a mechanism in place prior to closing. Like, we need to do a punch list, right? And we have to say, are we going to have to do a punch list where we come in, we have to agree on the punch list, and then you're going to do the work, and then we're going to come back in, right? Or do I have the right to come into the property while it's being built to review it? Because, like, once the walls are closed, I don't know what's behind it, right? I may want to get a property manager who's going to, or project manager, to take a look to make sure things are done correctly, right? So there's a ton of stuff to do with new construction as well. And then, is money held in escrow after closing, or how much time does the seller have until they can actually finish it, and then when does the buyer take over? So, and then when you're representing a buyer with new construction, a lot of these people who are doing this new construction are sole purpose entities. Well, then you just got to you have to understand as the buyer that once you give them your money at closing, that money's gone. It's distributed to the members, to the shareholders, whatever. What's the reputation of the seller, right? There are certain developers out there. You look them up. You go on the public records, municipal court of common pleas, like tons of litigation. Sometimes you can't figure it out though, because they have all these sole purpose entities. You have to find out who's the builder, who are the principals behind the builder. Sometimes to investigate that. So these are things that you should ask those questions, because I deal sometimes on the tail end. Oh my God, it's such a mess. Can you help me out? I'm like, I have an agreement of sale. Can't help you out that much, but we'll figure out what we can do. So, integration clauses, right? Obviously, whatever is within the 4 corners of the document, that's what you agree to. So make sure if something's in a multi-listing service, like advertisement, it's within the actual agreement of sale as well. Otherwise, it's not a material condition, and if they breach it, it's not a condition, obviously, either of the agreement. Seller's Property Disclosure Act. So again, sellers, when it's a pre-existing structure, and I think it's under 4 units, they have to disclose whatever material defects they know about the property, right? So there's a PAR form for it. So they don't have to do their own independent investigation. What they need to do is just tell you what they know, right? And that's it. So that is my presentation in a nutshell. So we have 8 minutes. Does anyone have any questions?
New case as is where is you were talking about?
Yeah, it came out, and actually it also talks about damages as well, like how you calculate damages when there's actually a breach of the Seller's Property Disclosure Act. I can't remember that part. I wrote the article in one ear, out the other. So, but there's a ton. There's actually, I think there's a second case I came across too that recently talked about the Seller's Property Disclosure Act. Yes.
Where can you get these blank bar forms at?
You can buy them. I mean, they're
March used to.
yeah, Pennsylvania Association of Realtors website. I think they're very helpful. I use them, and then what I do is I create an addendum to like my own attorney addendum to it. It makes it a lot easier. It makes the practice of law a lot easier. And people are, like, clients don't want to spend money on you creating a document from scratch. And a lot of times people who are not represented get scared when you show an attorney document.
How many forms do you have to buy at one time?
I'm not a sales associate for the Pennsylvania Association of Realtors, I don't know. Yes.
Listen, unless they've changed their rule recently, you have to be some form of member of BAR to get the forms. You just can't get the forms.
Okay. Well,
I'm telling you.
I know, okay.
That's why I was asking.
That's why I'm
Yeah.
correcting.
I don't remember how I got it, it's been so long, I haven't. I thought I'd be paid for it at one point.
You may have, well, as I say, originally, you could get it without being a member.
Yeah.
That's what I did.
Yeah.
Then they required that you become some kind of member.
Okay, okay. I know, I've taught at their classes as well, so I don't remember if there's some type of association.
Yeah, but you pay for the privilege,
Yeah.
and if you have enough
Yeah.
to justify it, you can do it.
I only need 4 or 5, that's all.
Well, you're gonna get, but they, again, I don't know what the package includes, but I think it's very helpful to get some of those forms I talked about, whether it's the agreement of sale, the appraisal contingency, the property disclosure statement,
I agree with you.
the
They usually
consumer.
are buying the cars, you know, they're not there.
Yes.
So, I mean, is there any place else where you can buy them? Yeah.
Are they on, like Jenkins has PA legal forms, but you can access, that has a ton of legal forms.
Yeah, I just think that sometimes people who go pro se get scared of that. And I think when you create a more of a form, you can, and not just agreements of sale, you have commercial leases, they have, by the way, they have commercial agreements of sale, residential agreements of sale, vacant lots, agreements of sale. You know, I think I personally think it helps my practice because I get deals done. When I do my own form sometimes with some deals, people get scared. So, yes.
I've been a renter all my life, so I'm one of the few that probably haven't bought.
You've been where?
I haven't bought a piece of property, so I've been a renter all my life. So in terms of title insurance that protects you against claims in the past, what happens if a claim comes forward? What does the title insurance actually solve?
The defendant, I used to work for the title insurance company, I mean, they're the lawyers that defend the claim.
Yeah,
That's
you call a
it's like
claim in, and
steroids.
they'll defend it up to the policy limit. So there's an owner's policy and a lender's policy. The lender's policy is the amount of the actual loan. So say we buy a property, it's a $100,000 purchase price, and we take a loan of $80,000. There'll be a lender's policy of $80,000, and there'll be an owner's policy of $100,000. They will protect you up to $100,000 as the owner of the property. So they'll deal with any defects with title. If there's fraud involved, then, you know, obviously you'll get your $100,000. If it's an investment property, you're not protected unless it's a construction loan from any improvements you make to the property or any increased value to the property. So you only up to that $100,000 in that particular situation. And at closing, I treat it as like the lender's policy, the owner's policy is paid by the actual buyer. And they overlap and they're like the palm of my hand. And then there's called endorsements, right? And there's some owners endorsements, but mostly they're lenders endorsements, like when you're dealing with condos, like there's an endorsement to protect you, to make sure the condo was formed correctly. So there's all these endorsements that you paid for. And then, you know, basically, the lender gets the ability to get protected on these endorsements, and you may not. And then there's also something called, by the way, a closing protection letter that I didn't go over, which is like basically insurance to make sure, because all the money goes to the title agent, right? So all of your money in the transaction, all the bank's money, what the title agents at the time of closing doesn't show up, and they go to Tahiti for the rest of their lives. You're getting the insurance to make sure that those funds are protected, and that the documents are actually recorded correctly and things like that. So, but to answer your question, if there was a claim saying, oh, there's a judgment of $20,000 that you refinance your mortgage, right? And after you bought the property, and then there's a judgment of $20,000 from a prior owner that should have been covered and dealt with when you purchased the property, your title company would go to the title company that handled that deal, like the purchase, and get what's called a letter of indemnity. And then so basically it would clear up that one issue. It may never get paid, but there's always someone, there will always be on the hook for that 20,000, like whatever the lien is. Now, if there was fraud involved in the transaction, and you can't buy the Brooklyn Bridge. I don't care if I enter into an agreement with you, or Ben Franklin Bridge here. So say I decide to sell you the Ben Franklin Bridge for $10, right? And you get title insurance. And then you find out that you really don't own the Ben Franklin Bridge. You go to the title company and you get your $10 back.
But in terms of buying a house, if there's fraud involved and there's a claim against you, you may potentially have to move, even if you're...
That's right.
Okay, all right.
So what usually happens, and this happens in transitional areas or distressed properties, maybe the person who sold it was a fraud or whomever. Usually the title companies, like, they pay off the person. They're like, because technically so if it's a vacant lot and I built something that's $300,000, then technically the people who have the real ownership interest in the property have to reimburse me for those improvements. So what happens is the title company usually says, listen, I have this amount of money, I can give it to you, step away. Not you, but the person who's making that claim that they have some ownership interest. And they do, and you don't. So really, it's like a payoff. So eventually that's what ultimately happens most times. Or the person who owns, who really had that interest in the property, which was never extinguished by your acquisition of the property, has to pay you off for any improvements you made to the property. Plus, like, think about it, if you paid, like, say there was a distressed property and there was like $30,000 worth of taxes. Okay, good. Sorry, I'm just like looking at my colleagues that we want, so I'm good. So I can stay a little bit longer. So, say there's taxes of $20,000 and that was paid at the time of closing. Well, the person who's claiming an interest in this property has to pay that. Reimburse you. They can't just take the property free and clear. So, any other questions? Thank you.